So I have an important update involving the California ammunition ban case Rhode v. Bonta. Judge Benitez just issued an interesting order in this case, so let's talk about this. But real quick before we jump into this video, if you think California's ammo ban, their ammunition background check is clearly unconstitutional, go ahead and hit that like button and subscribe. Also, I want to thank one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you check out USCCA. You can check them out using the link down below in the description section and also in the comment section. And once again, thank you to USCCA for supporting this channel. So like I said in the intro, in this video, I have an important update for you on the California ammunition ban case called Rhode v. Bonta. Rhode is one of those cases that California gun owners have been waiting to hear about for quite a while now. But essentially since February, Judge Benitez has been pretty silent on all of these cases, on the Rhode case and then the two big other cases, which are Duncan and Miller. Duncan deals with California's magazine ban, and then Miller deals with California's ban on so-called assault weapons. However, we received an order last week from Judge Benitez, which set the Rhode case for a consolidated hearing on the merits of the case, and that is set for July 17th. This was an interesting move that I don't think many people were anticipating, and I think it's going to have important implications not just for this case going forward, but also maybe some of these other cases, including Duncan. Now, if you're not aware, Rhode v. Bonta deals with the state of California's restrictions on the purchase of ammunition and also the background check system that you must go through to purchase ammunition in the state of California. This law was passed through Proposition 63, which requires purchasers of ammunition to undergo 1 or 2 background checks to confirm they can legally purchase ammunition. There is the basic eligibility check and then also the standard eligibility check, both of which come with a different fee that you must pay. The law in California also restricts the ability for someone to be able to purchase ammunition online and then have that shipped directly to your house unless you have something like a COE and an FFL 03. There are some ways you can get around it, but for the general person, the general citizen in the state of California, those are the laws that are in place where you couldn't purchase online and have them shipped to your home. That is essentially the law in question here in California that's being challenged in the Rhode v. Bonta case. Judge Roger T. Benitez, or St. Benitez as some call him in California, is the district court judge who originally reviewed this case and ruled on the preliminary injunction in this case. Originally on review in this case, Judge Benitez utilized what can be best described as a version of text as informed by history and tradition. Judge Benitez described this test as the simple Heller test. Using the simple Heller test, he stated that it is obvious that the California background check laws that de facto completely block some law-abiding responsible citizens from buying common ammunition are unconstitutional. He pointed out in his decision that under the simple Heller test, the review could end at this first step and he would not need to go any further. However, he also went on in his order to find that an ammunition background check has no historical pedigree. In fact, a background check required each time ammunition is purchased has never been implemented before. Now, after he granted the preliminary injunction, what ended up happening is what many people call the ammo day in the state of California, where essentially I think only for about 24 hours, the preliminary injunction was in place before the state of California decided to go up to the Ninth Circuit. Oral arguments were actually held on Rhode back in November of 2020 in front of the 3-judge panel in the Ninth Circuit. But the ruling of that panel was then essentially put on hold. After the Bruen decision, the panel in Rhode then requested for the parties to issue supplemental briefs on how the Bruen decision impacted this specific case. The state of California submitted their briefs, and at first they argued that Bruen had no impact on the case whatsoever because they stated that ammunition restrictions in the state of California do not implicate conduct protected by the Second Amendment. But they also argued that if the panel found that if there was a right to purchase ammunition under the Second Amendment, then the Ninth Circuit should simply remand the case back down to Judge Benitez for him to reconsider the case in light of Bruen. Rhode then went back down to Judge Benitez for him to rule once again in light of Bruen, again to decide whether or not he would grant a preliminary injunction or not. At the beginning of last December, all 3 of these cases, the big ones, Miller, Duncan, and Rhode, and also the Fouts Billy Club case, had a consolidated conference before Judge Benitez. And what ended up happening at that conference was that Judge Benitez gave the state of California 30 days to present a spreadsheet of enacted laws and regulations which relate to the cases at hand. Then the plaintiffs in those cases were given 30 days to rebut those examples. After that, the parties were then given 10 more days for both sides to file replies to that spreadsheet rebuttals. So essentially, all the cases were put in a holding pattern for another 70 days. But since the final documents were submitted back in February, I believe, we really haven't heard much on any of these cases. Well, at the end of last week, Judge Benitez finally broke his silence and he issued an order in the Rhode case. Judge Benitez issued an order setting a consolidated hearing on the motion for preliminary injunction in the Rhode case. But he also did something interesting. He set the same hearing to be a trial hearing on the merits of the case. What is interesting about this is that the hearing will be on two different things. It will be on the granting of a preliminary injunction, whether or not a preliminary injunction should be granted, and then also an actual trial on the merits of the case at the very same time. The order states that a hearing on plaintiff's motion for preliminary injunction take place on Monday, July 17th, 2023 at 2 p.m. in courtroom 5A. Pursuant to the Federal Rules of Civil Procedure 65A2, the court intends to consolidate the hearing on the motion for preliminary injunction with a trial on the merits. At or prior to the hearing, the parties should be prepared to address, among other things, and then he lists the things that he will hear at that trial. A, the plaintiff's continuing Article 3 standing. B, whether plaintiff's conduct is covered by the text of the Second Amendment. C, relevant historical analogs. D, applicability of footnote 9 in New York State Rifle and Pistol Association versus Bruin. E, the Dormant Commerce Clause. F, preemption under 18 USC section 926A. G, whether judicial deference is owed to laws produced by ballot measure Proposition 63. And whether additional discovery is necessary, if so, the specific discovery that is needed. What this means is that after the hearing, there is the potential that Judge Benitez may forego just issuing a preliminary injunction. Instead, if he wanted, after the trial on the merits, he could make a final ruling on the entire case. Remember that a preliminary injunction is just a temporary halt on the enforcement of a law until a case is decided on the merits of the case. Here in this case, an injunction would essentially not be needed if after the hearing, Judge Benitez decides that no additional discovery or fact-finding is needed at all. He could then just simply decide that he wants to rule on the briefs and arguments that were presented to him and ultimately just resolve this case altogether without even issuing a preliminary injunction. I think this further signals that Judge Benitez is essentially done with these cases. He's done with these cases being stuck in this continued middle preliminary injunction stage. Having a trial on the merits gets this part of the litigation completely done. It kind of gets this off his plates and then essentially sends it up to the Ninth Circuit on a final resolution and kind of makes it their problem. It also moves this case up the ladder on appeals on a final judgment instead on an interlocutory posture on whether or not a preliminary injunction was appropriate or not. It also means that if this case ever makes its way up to the Supreme Court at some point, that would mean that it's much more appealing to the Supreme Court because it's not an interlocutory issue, but it's a final resolution of a case. I'm also now curious and somewhat worried that maybe the same thing will potentially happen to the Duncan v. Bonta magazine ban case. I do have now some slight concern for Duncan, maybe it getting bogged down a little bit longer. It could be just isolated to Rhode, that maybe he's just doing this for this specific case, maybe because it's involving Prop 63 or maybe something else, I'm not sure. But it's really interesting to see that he did this. I don't think many people were anticipating that he would consolidate the preliminary injunction hearing with also a hearing on the merits. But I think many California gun owners will have their eyes on the July 17th hearing. Again, very interesting for everybody asking me what's going on in California with these California cases. That's a quick update on the Rhode v. Bonta ammo ban case. Some interesting developments, and now we will wait for July 17th, and all eyes will be on that hearing to see what happens. But of course, if anything else happens, if anything else develops, I will let you all know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.